money and the loss. But it is the only way in which courts can formulate a compensation. It is the value that we attach to a loss which is actually, we can't fix it.
Thank you. Thank you, Mr. Mab.
Thank you.
Mr. Mullins, I just need to understand the amendment or the development, sorry, that you're advocating for. At the heart of it is that the element of personal attachment, personal attachment of the compensation should fall away. Am I right? Or
the development we are proposing is that following the formulation by the Supreme Court of Appeal of the test, subjective awareness is regarded as a sine qua non to qualify for general damages. Now, I've already said that the test is slightly differently worded, but the net result is
it compensates the injured person.
Yes. So no awareness, subjective awareness of loss results in no general damages. So the court does not even consider general damages because you are not aware according to the finding. Our proposal is that awareness, subjective awareness, and the ability to demonstrate some functional use for monetary award cannot operate as a prerequisite to the legal recognition of the loss of amenities. So the development is, it can't be a prerequisite, but it can be a factor to be considered.
Right.
Subject to not further differentiating.
How would the principle, how would the approach be? How would it work practically? What would we be looking for?
Practically, it would play out as it played out in the court of first instance, where a judge is provided with the medical records and the evidence and argument is being made, and the judge considers all of the factors. All of these factors that is placed before the court, all of that record was also placed before the court of first instance. And the court judicially considered it and arrived at the figure of 2.2 million rand, which the court found to be just and fair. But that is the manner in which we propose this is to be done. But you cannot make the awareness, the subjective awareness, a prerequisite to even enter the realm of non-patrimonial damages.
And then what would be at the heart of the distinction between general damages and special damages?
The general damages is a monetary compensation for actual loss. It is determined by asking yourself, what is, as a result of the negligence, what is the additional expenditure that this individual will incur during his lifetime? And you quantify that, and you attach a value to it.
It seems to me that that principle recognizes it's for the benefit of the injured person.
It does not compensate loss. It compensates additional future expenditure.
Okay, that's special damages.
That's your special damages.
Yes.
It does not compensate the loss. It compensates the additional expenditure that an individual will incur in his lifetime as a result of the injury.
Yeah, and I'm trying to assess that on your principle, how the personality of general damages would work out. In other words, the injured person is compensated generally for the loss, the injury to them specifically. It's to their benefit.
Yes. The exclusive benefit
yes.
that was advanced, I do believe, is it's the impossible. Because now the court finds that this child is in a vegetative state. So and I thought to myself, what can I think of that one can do to his exclusive benefit?
Yes, if it's not for...
It's a circular argument because there is no such thing.
Yeah, if it's not for the child's or the injured person's exclusive benefit, whose benefit is it for?
But if we ask the benefit, we are moving to the functionality. And that is what Justice Willis in NK in the cause of matters said as well. The court should not look at the functionality of what it is to be used for. This is a payment for amenities lost. It might serve no function.
Perhaps a different way of approaching this inquiry is looking at, if your approach is, the court should not be looking at what the functionality is. How then do we frame the developed principle or the developed approach? What is it?
The developed approach would be that the court is not judicially barred from considering and determining general damages because of a lack of subjective awareness. In determining general damages, as has been pronounced in many a matter, a court and a judge is given a wide discretion to consider everything and anything relevant in arriving at a just and equitable figure to compensate not expenses, but to compensate the loss of amenities.
And then don't we risk commodifying that loss if it's not exclusive to the person, the injured person?
Again, I cannot think of something that you would do which would by implication always be to the exclusive benefit of a person, especially if you, let's take a wheelchair for instance. You buy somebody a wheelchair. That wheelchair you can say is to the benefit of the injured party in that it affords him more mobility or her more mobility, but it is also to the benefit of the person that has to move him. It's easier than carrying him.
That's exactly what I'm saying.
So the exclusive benefit tail or angle to that argument, I cannot think of something which would normally be exclusively to the benefit of an individual in this context.
Yeah, so third parties, it would be to the benefit of third parties as well. In other words, could be to my benefit as the person who experiences perceives the injury.
Yes. If we look at the present matter and we look at something like, for instance, a hoisting system. Now he was provided with a hoisting system because he was too big for his mother to pick up. So you'd put a hoisting system above the bath and you would hoist him up and you would place him in the bath and wash him. Now, to whose benefit is that? It's to his benefit because he is cleaned, he's taking a bath, but it's also to the mother's benefit. And there are many things that you can say is to the benefit of more than one person, but to say that general damages must be to the exclusive benefit of the victim, coupled with the finding of non-awareness.
Yeah, my problem is
circular.
Or let me not say my problem. What I'm not quite working out practically then is the other person other than him or her, the injured person, to whose benefit the general damages are. Does that mean that any third person has a claim, is a potential plaintiff?
No, I do not.
I'm trying to work out what's the range of the developed principle.
The range of the developed rule is no different from the current range. And let's look at this matter. There's, and we quote in our heads of argument, various other matters where courts dealt with plaintiffs or with children in similar positions, where courts expressed there's no awareness, and still they were afforded general damages. Cases of this type of nature, where the courts actually decline general damages due to a lack of awareness, are very few and far between. So all we are proposing is, let's get back to the basic principles of general damages and let judges consider amounts having regard to anything that they judicially can do so, obviously subject to not discriminating any further. But that is our argument in totality is aimed at uplifting or removing the legal obstacle to qualifying for general damages. You cannot place this obstacle there. You can consider it, again, subject to what Justice Colopin also pointed out, not discriminating, but that is where it belongs. And that is exactly what the Court of First Instance did in the present matter.
Should a distinction be drawn between the situation where the patient is responsive and the situation where a person is unresponsive? In responsive, and I read what Boberg said about that, he said, yes, obviously where a person is aware of the extent of his or her loss, then that may give rise to a very substantial award. My point is those considerations cannot be taken into account with an unresponsive person because that person cannot respond or display an awareness of the situation in which he or she is. But should that then diminish the award of damages, or should that person be entitled to exactly the same as a person who is able to express his or her awareness of the position he or she is?
Justice Basol, I must profess, and during the discussion I had with Justice Colopin as well, Justice Colopin pointed this out and it became evident to me. It's not necessarily something that I specifically considered, but it is now being debated. And I agree. I agree that the lack of awareness should not be used in a manner that differentiates between one individual and the next. I accept that. But I also accept that general damages has a personality element. That I also accept. And my proposition and argument is that we should leave it to judges and to courts to decide matters and exercise their discretion considering everything, and obviously refraining from taking a certain category and discriminating against an individual.
But does that not bring us to the point where the emphasis should be objectively on the injury itself and not on the compensatory aspect
I accept.
Flowing from that injury?
That I accept. And Justice Basson, again, if we look at what is happening in the courts out there, I think that is to a large extent how general damages is being applied at the moment. We have a system where continuous judgments are made on paper, having regard to, well, that's the nature of the injury, to be a fibula fracture, so that is value X. So to a large extent, I believe it might be due to overload and workload and the amount of cases, but that is how, in practice, it is being applied to a large extent. So determine the loss, look at the loss, and compensate that.
And the same can be said when one deals with pain and suffering. Apart from the fact it's very difficult to pinpoint whether or not a person suffers from pain or not. And I think it's Boberg again that says there could be some kind of a residual consciousness, but leaving aside the whole awareness element, and one should also bear in mind that an unresponsive person cannot always convey that he or she is in pain. So would it not be advisable then to also just concentrate on the objective nature of the injury and take into account that this injury has destroyed this person's entire life?
Justice Basson, I'm inclined to agree that such an approach will result in the best judicial certainty in approach and would result in differentiation, possible discrimination being eliminated from the equation. I accept that.
Thank you, Acting Deputy Chief Justice. Advocate Myburgh, can I just explore some of the questions that I think Justice Matopo began, and he said he didn't have the time. So I have the time. Isn't the problem that the entire structure of the argument of the government premised on some sort of a special recognition of mental awareness rather than the fact of being alive? And in a sense, that's a reflective of the general discrimination, and I think that's what the second amicus says. That's reflective of the embedded discrimination against mentally disabled persons, because there's some premium to this idea of being mentally conscious as opposed to putting a premium on the idea of being a person.
I accept. I accept also that we can have lengthy debates and discussions, probably philosophical and more technical in some instances, regarding the authority that brought us to where we are. And we can have a debate regarding the Collins judgment, and we can juxtapose that to the NK, or the Causa judgment by Justice Willis, and how this approach developed. But in principle, what the SCA did is to say that this is the test. Why? Because it's always been like this.
Yes.
That is in essence.
Yes, but I mean, doesn't the constitutional structure require us to place emphasis on the fact of being a human?
Yes.
Yes.
Justice Ngcukaitobi, I'm going to be blunt. We cannot allow a Supreme Court of Appeal judgment to stand which calls a child who is severely mentally disabled equal to dead.
Well, I mean, that
It
comes from the
affronts.
Collins judgment. That was the judgment of Judge Scott, that a severely mentally disabled person is equivalent to dead. And regrettably, it's also at the heart of the SCA judgment. In fact, it's not at the heart of the judgment, it's expressly there.
Yes.
Now, that's why I'm asking whether, isn't the problem really that the entire structure is premised from a discriminatory departure point?
Yes.
And that's fundamentally inconsistent with the Constitution.
I have the utmost confidence in making the submission that the approach that was adopted is ignorant of the constitutional principles of dignity,
Yes.
of equality, and the underlying principles of how our law developed to treat and recognize disabled individuals, yes, but more importantly, people. Look how far we've come in recognizing the inherent worth of everybody, of being a human. And I find myself, as I said in my opening remarks, juxtaposing Mr. Makwanyane against this child. And I look at that treatment and I look at this treatment. And I can categorically state that this treatment of this child does not align with the constitutional principles enunciated and enforced by this court in Makwanyane.
Yes. I've got a couple of other questions. I just want to make sure that I don't fall foul with this acting Deputy Chief Justice's plan about tea. Should I continue? Yes, thank you. The next point I would like to explore with you is why you accept that there is a common law rule in this case. From the judgments of the SCA, there are three judgments on this point. The first case was Gerke in 1966. The next case was Reineke, and the last 1991, and the last case was Collins in 1995. Reineke and Gerke are aligned, although there are nuances. and Collins departs from them. Why is that the common law?
Justice Ngcukaitobi, what I can safely say, and again, I had to be very attentive to what invokes the jurisdiction of this court. But what I'm confident to say that subsequent to the handing down of the majority judgment in this matter by the SCA, that has established the common law. So following that judgment, I do not want to be heard to say that the court erred in applying the law. I'm careful to tread there. I'm confident and comfortable to make the submission that following the judgment of the SCA in this matter, the common law principle has now been clarified as to what they pronounced.
Yes, that's the point I'm driving towards. What has happened here is that the SCA has formulated a new rule, not based on any previous body of law. And that new rule is coming to this court to decide whether it's correct or inconsistent with the Constitution. So we are in exactly the same position as the SCA to develop the content of the rule.
That is correct.
But we do so with the Constitution in mind.
Yes.
Yes.
As I said, the word dignity appears once in the entire judgment. And I think that is indicative of where, in my submission, the constitutional infusion was missed. It's evidence of that, at least.
But you would accept that prior to the statement of the law by the SCA, there can be no common law on this topic flowing from Gerke, Reineke, and Collins.
Justice Ngcukaitobi, I will accept that there were conflicting authority.
Indeed.
That's the very best. Gerke, Reineke on the one side, and Collins on the other side. And the Supreme Court of Appeal, having regard to the history of this claims in general, preferred the methodology pronounced by Justice Scott in Collins, yes.
Yes, but those three judgments cannot be said to constitute the body of the common law.
I accept.
Yes. Now, then, the next thing is what you accepted in your argument, which I have a little bit of a difficulty with, which is when you look at general damages and you split general damages to loss of amenities as well as pain and suffering. And you seem to accept that for pain and suffering, the mental awareness would be a sine qua non. Did I get you right there?
No, I accept that it might, if there is no awareness of it.
Why?
It might result in...
Why?
Justice Ngcukaitobi, that was the view I held.
No, but I'm asking why should this court...
But I'm the first to accept that in my interaction with Justice Collopin and Justice Passon, it became evident to me that what I've proposed and what I concede in that regard might create further loopholes and further difficulties and further differentiations. I'm fully prepared to accept that. And in developing my argument to this court, I accepted that subjective awareness of pain and suffering will impact or might impact on the amount you are awarded for it.
Yes, no, I understand. But your current argument now, forget about what you said earlier, is that mental awareness for pain and suffering is not a sine qua non.
No.
Yes.
And that is the crux of my entire argument, is there can be no sine qua non for general damages, to qualify for general damages. You can consider various factors and exercise your discretion, but you cannot elevate any of those factors to a sine qua non to qualify for it.
Yes.
That is the crux of what I am arguing, and that is what the crux of why we say that the rule, whether it enforced or created by the SCA, is constitutionally invalid.
Yes. Now, if your argument is that it's a factor but not a sine qua non, the difficulty still arises as to what weight is given to that factor and whether or not it does not again privilege mental awareness and proceeds from the discriminatory premise that there's something wrong with being mentally disabled.
Justice Ngcukaitobi, I will concede that the best manner in which to evolve and to adapt this whole legal concept is to actually to remove the subjectiveness entirely from it.
Yes, certainly insofar as the determination of the entitlement is concerned. Quantum, what would you say on quantum? Because what I understand from Gerke and Reineke is that mental awareness remained a component of the determination of the quantum. So if we're removing it from an entitlement, do we still keep it on quantum or we remove it entirely?
No. Again, I believe it would be appropriate, and then again, this is subject to not any of the factors being used to unfairly differentiate. I believe it would be appropriate, having regard to general damages and the nature of it, to afford a judge awarding it to consider as many a factor which is relevant as possible. But none of those factors can be used as a qualifying factor. It can be elevated to a sine qua non, and none can be used in order to differentiate and subsequently discriminate.
Sorry, Mr. Makwanyane, I don't want a vague argument. I'm dealing specifically with mental awareness. Should it be removed entirely in the assessment of quantum or not?
Yes.
Yes. Thank you, District